To order. Back to pursuant to Standing Order 1082. Committee is studying the subject matter of Bill C-44, an act to implement certain provisions of the budget, tabled in Parliament on March 22nd of this year, and other measures. We had heard from representatives from Finance Canada yesterday. Starting this afternoon, we'll start on Part 4, Division 3, Financial Sector Stability, and we have with us Lisa Pasak, Director, Financial Services Division, Financial Sector Policy Branch, Leanne Orsi, I'm not sure if I got that right, Leanne, who's the Senior Advisor, Financial Institutions Division, Financial Sector Policy Branch, and Justin Brown, who's Chief Financial Systems Division, Financial Sector Policy Branch. Welcome. The floor is yours. You have an opening statement, and then we'll go to questions.
Thank you, Mr. Chair. This proposal seeks to strengthen Canada's bank resolution regime by formally designating Canada Deposit Insurance Corporation as the resolution authority for its members, and by requiring Canada's biggest banks to develop and submit resolution plans. The proposal would also clarify that the Superintendent of Financial Institutions may set criteria for how domestic systemically important banks must meet the requirement to maintain a minimum capacity to absorb losses. The Canada Deposit Insurance Corporation has been responsible for providing deposit insurance for Canadian banks since it was established by the Canada Deposit Insurance Corporation Act in 1967. Following the financial crisis and in line with the development of international standards, CDIC's powers and tools have been expanded to facilitate the orderly resolution of its member institutions in the event of a failure. The proposed changes would formally designate CDIC as the resolution authority for its member institutions. In this capacity, CDIC has undertaken a number of initiatives to ensure its readiness to deal with any banking failures. One of them pertains to the development of resolution plans, which describe how a systemically important bank could be resolved in an orderly manner while ensuring the continuity of critical financial services and protecting financial stability. In 2015, Canada's systemically important banks were asked to work with CDIC to prepare plans demonstrating how they could be resolved in a manner that ensures financial stability in the unlikely event of their failure. The proposed changes would put the requirement for Canada's largest banks to develop resolution plans in legislation and provide CDIC with the authority to set out the framework for these plans in a bylaw. Together, the proposed changes would provide additional transparency regarding CDIC's activities as resolution authority for its members, which should facilitate CDIC's role in supporting the stability of the financial system. This proposal would also clarify that the Superintendent of Financial Institutions may set criteria for how domestic systemically important banks must meet the requirement to maintain a minimum capacity to absorb losses. The requirement for systemically important banks to maintain a minimum capital to absorb losses is set by the Superintendent and met through additional regulatory capital and debt that is subject to conversion into common shares in a failure, through the exercise of CDIC's bail-in power. Thank you, Mr. Chairman.
Thank you, Ms. Pisak. Do we have any questions? Mr. Sabero? And then Mr. Ouellette. Mr. Sabero.
No. Thank you, Mr. Chair. Good afternoon, everyone. Welcome to committee today. Nice to see you, Leanne. We interacted before in a prior career. In terms of the change in role on CDIC, can you guys comment in terms of how this fits in with the changes that have occurred over the last several years and since the financial crisis? That's my first question. My second question is with regards to bail-in. I left a financial institution two years ago now, where we were having initial discussions and going along the way in terms of having bail-in securities put in place by the banks. So in the event that there was some disruption to the financial sector, that they could be converted and that bondholders would share some of the risk. Can we get an update on that? Thank you.
So in answer to the first question, over the past several years since the financial crisis, CDIC has been given a variety of tools and powers, but it's never been formally designated as a resolution authority. But many of the powers and tools that they have would allow them to resolve a bank in the case of a failure. This is just, in that sense, mostly a formality to say that that they have this power and that they can require banks to provide the resolution plans. As you know, in Budget 2016, we implemented the process for bail-in. It's a relatively new process internationally, in which you issue debt and securities that would then be converted into common shares in the case of the failure of a domestic systemically important bank. And that process has been underway. This is a clarification of the roles and powers of the superintendent within that process. So that the legislation is in place. We'll be working towards regulations to put it in place.
Thank you.
Merci beaucoup. J'aimerais savoir comment...
Thank you very much. I'd like to know how the superintendent will be able to determine the exact amount. What is the criteria necessary determine the ability of banks to absorb losses?
The purpose of this amendment is not to determine how the amount is calibrated, but more how it's satisfied, so the criteria for what instruments may be eligible. But I'm happy to respond to both. On the question of how it would be calibrated, we would be looking at what losses a domestic systemically important bank could plausibly experience based on historical experience and stress testing, and also what level of capital is necessary to restore the bank to adequate levels of capitalization with a buffer beyond that to establish confidence in the bank. This is a bank that has failed, and so the intent is to recapitalize it such that it can continue to remain operating. In addition to the calibration of the amount, this amendment that we are seeking views on will allow us to establish criteria as to what instruments, regulatory capital or long-term debt, are available to meet this requirement. We are seeking flexibility here in terms of not only calibrating the amount, but also how to satisfy this amount, given that this is a new standard and there's evolving market practices as well as international standards.
I was just also wondering who constitutes the committee? Alors, qui va constituer dans cette comité?
So who makes up this committee, which is mentioned in paragraph 18.1?
So it's the Office of the Superintendent of Financial Institutions, it's the Department of Finance, it's the Bank of Canada, the Financial Consumer Agency of Canada, and the Canada Deposit Insurance Corporation.
A final question. Do all the corporations or banks have to maintain a plan of resolution at all times, or is this something that they have to do at the last minute? Well, it applies only to the 6 biggest banks in Canada.
Financial institutions. And they're in the process of developing these plans now. And it's a bit of an iterative process. You try it once, you see, do you think that's good enough, and you go through the process. And they're working with...
They'll have a plan on file, and then if something does occur, they can...
And, well, we always, supervision is ongoing, and if something comes up that they think would warrant a change in the plan would be updated.
Thank you very much.
Thank you both. Mr. Deltel.
Thank you, Mr. Speaker. Mesdames, Messieurs, soyez les bienvenus à votre...
Welcome to your House of Commons. We understand that in your sector, you're a little bit the guardians, if you will, of economic stability within Canada's banks, which leads to a consecutive adjustment given the new reality. Can we say that with the changes that are being brought, we understand that the bill focuses, takes an overall approach, but in the amendments, are these amendments that are just updates, or On the other hand, do these make deeper changes when it comes to the management and the security of Canada's banking system? Well, I would say that this is more of an update than a major change, because this really reflects the changes, the decisions that had already been taken for CDIC. And in terms of the changes that are being made to the powers of the OSFI, well, I would say that this is more of a clarification of the office's powers. Without getting too much into the weeds, we know that there was an issue with mortgages a couple of weeks ago when a mortgage business saw their capitalization melt like snow in the sun. When it comes to protecting the banking system, does this affect the real estate system and mortgage loans, or is that a completely different system?
Of the particular institution falls in the purview of the superintendent of financial institutions as well. And the superintendent also has powers in relation to setting expectations for how mortgages are written, for example, underwriting standards, that sort of thing. So to the extent that a company is involved in mortgage underwriting, they're subject to supervision by the superintendent of financial institutions at the federal level. If it's a federally regulated institution, the provinces, of course,
so
do
it
their own
belongs
thing.
to you in your hands? It belongs to your responsibilities in your hands?
No, the superintendent of financial institutions.
Okay.
Just on that point, the mortgage company, and I can't think of the name, that is affected at the moment. They've come out, home, yeah. They've come out with a plan. Do they have to run that plan by the superintendent of financial institutions before they come out with, or is that?
On the day-to-day supervision of financial institutions, the questions are really better targeted to the superintendent. But of course, he has ongoing, and as I think he has said publicly, is monitoring the situation very closely.
Okay, we're not really on C-44 in that question anyway,
No.
so I could be ruled out of order. Mr. Dussault.
Merci, Monsieur le Président, et merci pour...
Thank you, Chair, and I'd like to thank the witnesses for being here today. I'd like to look more closely at Section 109 and 110 of the bill. First of all, Section 11, which amends Section 11. It says that the board will have to develop and maintain a resolution plan for the boards of the BISIs, the DSIBs, I should say. And then in 111, it says that it has to be approved by, well, it says...
Not effective unless it has been approved in writing by the minister. Pouvez-vous exprimer un peu la raison pour laquelle vous avez décidé de mettre cette provision?
Can you explain, please, in detail why the approval of the minister is required when it comes to these resolution plans?
I guess first and foremost, the Minister of Finance is responsible for financial sector stability. So his overall responsibility for financial sector stability would include making sure that should one of the domestic systemically important banks, or DSIBs as we say, gets in trouble, that they have a plan to fix themselves. Do you want to talk about that process?
Je dirais aussi c'est en ligne avec d'autres pratiques pour...
I would say that also aligns with other practices when it comes to creating regulations for the CDIC. The process begins with the Board of Directors of CDIC, except when it is a question of internal regulations. If it applies to Canadian industry and financial institutions, and issues of governance, well, the normal practice is to go to the Minister of Finance for approval. It's a question of ensuring that if we're putting a regulatory burden on the industry, then it's normal practice to ask the minister. Do you think that this could slow down the process? Because I imagine that in certain situations it's important to be reactive and to be able to act rapidly. So if a bank is facing major problems, is there a question of rapidity, the efficiency of processes to ensure that a plan can be put in place quickly and also to ensure that it's implemented quickly? Well, it's a question of approval of the requirements and the process to submit plans. So this is something that is done in advance. This doesn't concern the implementation of the plans. So in a specific situation, this doesn't deal with specific situations. This deals more with the planning for those situations. So if I understand the process, a DSIB, if it finds itself in a situation which is defined by the Superintendent of Financial Institutions, when they're in that situation, it would be then that the board would ask for a resolution plan, if I understand the process. Is that how it works?
In fact, started working with the institutions in an informal basis without, the legislative push to get them there. So they already, in fact, are working on developing plans to put in place to make sure that they would be in a position to resolve themselves should it ever be necessary to do so.
Ouais. Non, je pense que c'est tout pour moi.
I think that's all. Thank you.
Leipert.
Question, and I don't know if you're in a position to answer it, but I see the Bank Act is mentioned in here. Is there any, can you give us any status on the review of the Bank Act that's underway? And if that's not in, if that's not in order, Mr. Chairman, I leave it up to you. But is there any, can you give us any update on the review of the Bank Act?
I can say that the Bank Act review is ongoing, and there is, we've had a first round of consultations, we've had some input. They're in the process of considering that input and developing the next steps at this point.
And is there a timeline?
Well, the budget last year amended the date for the deadline for the Bank Act renewal to be March 2019, so clearly there's a deadline.
Okay, thank you.
Okay. All right. Thank you very much, and thank members for their question. I'm wondering, Ms. Pisak, if it's okay with the committee if we jump to number 19. Ms. Pisak is on that. Division 19 as well on the proceeds of crime. If we can jump there, and then she doesn't have to stay and wonder all afternoon. And Maxime Beaupay is here as well. Maxine is the Chief Financial Systems Division, Financial Sector Policy Branch. And we are dealing with Part 4, Division 19, Proceeds of Crime, Money Laundering, and Terrorist Financing Act. The floor is yours again, whoever is starting.
Well, first of all, thank you very much, Mr. Chair and members of the committee, for adjusting your schedule. So the Proceeds of Crime, Money Laundering, Terrorist Financing Act is would be amended by Division 19 to, among other things, expand the list of disclosure recipients of financial intelligence to include the Department of National Defence and the Canadian Armed Forces, and to include beneficial ownership information as designated information that can be disclosed by the Financial Transaction and Reports Analysis Centre of Canada. Furthermore, it makes several technical amendments to ensure that the legislation functions as intended and to clarify certain provisions, including the definition of client and the application of the Act to all trust companies. The Government of Canada is committed to combating money laundering and terrorist financing, and while we maintain a robust and comprehensive anti-money laundering, anti-terrorist financing framework, it must evolve to ensure the integrity of the financial system and the security of Canada and Canadians. The Act expands, including the Department of National Defence and the Canadian Armed Forces on the list of disclosure recipients would allow the FINTRAC to relate information as it relates to the threats of security of Canada. And we would define threats to the security of Canada as defined in the CSIS Act, so it's quite a clear definition there. It would allow for FINTRAC to disclose information that it has on beneficial ownership. Sometimes reporting entities provide this information to FINTRAC. They're not currently allowed to provide that information on to competent authorities. And this would allow them to do it. And there are a variety of technical changes that would strengthen the framework, support compliance, and improve the ability of reporting entities to, operationalize the Act and ensure that it functions as intended. Some would relate to clarifying and streamlining regulation authority, clarifying that all trusts are covered. It would ensure that MSBs who are subject to United Nations and Special Export Measures Act, Economic Measures Act, I always forget that one, sanctions cannot re-register as an MSB with FINTRAC. And there are some technical changes to correct English and French and clarify some of the concordance. Thank you.
Okay, we're open for questions if anybody wants to start. Ms. O'Connell.
Thank you, Mr. Chair. Thank you for being here. I'm just curious, and perhaps this is really technical on the process of how it would actually work, but how would FINTRAC determine any irregular occurrence, and then how often are they sharing that information? Or is it as soon as something irregular pops up, it is shared immediately? Or what is that reporting or communication between FINTRAC and then National Defence or the Canadian Armed Forces?
Okay, so usually when they would come to the conclusion that there was an issue that related to the security of Canada, it would be as a result of doing some analysis. And it would be probably not necessarily from a single source of information coming into them, but it may be from their ability to put together various sources of information and say that there would be an issue here. And then they would have to look at whether or not it meets two tests. In the first instance, they have to say that there are reasonable grounds to suspect that the information would be relevant to the threats of Canada, and as defined under the CSIS Act. And then secondly, they would also have to have reasonable grounds to suspect that the information would relate to threats to the Department of National Defence or the Canadian Forces.
Thank you. And then following up on that, how would FINTRAC determine an unregulated trust if it was set up in a province or territory? Or do you have agreements with provinces and territories to also report anything irregular or what might be a concern?
So most trusts are right now already registering as reporting entities. There's been some, but the legislation it talks about regulated trusts must register. So this would allow for trusts who are not currently regulated, most of which I think we've identified, to now be. They would be able to go to them and say, no, you're included now. It's not just regulated trusts, it's all trusts.
Okay, so that's how you would capture it, by essentially establishing that all of these trusts now have to go through that federal process.
Yes.
Great. Thank you, Mr. Chair.
Thank you, Ms. O'Connell. Mr. Dussault.
Merci.
Thank you, Chair, and thank you again for your presentation. I'm particularly interested in the question of beneficial ownership, the beneficial owners. And CRA already has an agreement with FINTRAC to receive this information, and one of the problems that I've seen is that the CRA collects a lot of information from FINTRAC on transactions of $10,000 or more. And the problem that we've seen recently with the CRA is that they weren't doing a follow-up on the documents that they received from FINTRAC to determine if the information they'd received had been effective or not. But in the case that I'm looking at today is that right now you're unable, for example, if you have information on beneficial ownership of an entity, a corporation, you can't say to the CRA, you can't give an example. Is that the problem now? Well, right now the situation is if FINTRAC has information, they can't share it with FINTRAC or the RCMP or other. They can't share the information that they already have. The amendment will allow FINTRAC to say, well, here we've identified transactions that are suspect, major transactions, and we can even say, according to our information, the ultimate beneficiary is X person or X country or is in X country, etc. Yes. Okay.
But Robert?
Thank you very much. Thank you very much, Mr. Chair. So I was just wanted to delve in a little bit more into the Department of National Defence and the Canadian Forces. So under the Article 430(1), subsection 55(1), the Department of National Defence and the Canadian Forces, if the Senator has reasonable grounds to suspect that the information is relevant to such a threat as it relates to the Department or the Canadian Forces. So who's actually going to determine if that's relevant? Because there's always this idea of mission creep, and I'd just be interested to know, you know, at some point, you know, the Department of National Defence or the Canadian Forces, who in that department is qualified in financial matters, and how they would determine that it's a relevant threat to them, and what they would do with that information in the long term. So I'm a little bit concerned that there's a bit of perhaps a bit of mission creep in that, because even, you know, for instance, the RCMP, you know, they have difficulties sometimes understanding all of these things and working with all the other agencies.
So it would be up to FINTRAC to make that. FINTRAC would have the information on hand, and FINTRAC would then do their 2 tests. Is there a threat? And do we believe, from what we know, that this would have pose a threat to the security of Canada? Therefore, we should disclose the information. So it's not going to be up to anybody at the Department of National Defence to be making any financial analysis. It would be.
But they could conceivably say to FINTRAC, we would like this information. Could you share it with us?
No.
So they are.
Because I don't see anything preventing that. What I see is allowing it, but I don't see anything laying out the framework or the criteria in order to ensure that information is protected.
So there are a lot of provisions in the PCM-LTFA that protects information that is under the custody of FINTRAC, and one of those provisions that reinforces the separation between FINTRAC as an arm's length agency and law enforcement, for example, that are disclosure recipients, is the fact that FINTRAC controls the information, and we have legislated thresholds in the Act that allow FINTRAC to disclose. So as Lisa was indicating, FINTRAC is the one that applies those legislative tests to determine whether information under its custody can be disclosed to a recipient. So it is not up to the recipients to make that test. And furthermore, under the Act, it is not possible to request information from FINTRAC. So it is possible for disclosure recipients to submit voluntary information record. So and this is how FINTRAC can help investigations when law enforcement is, for example, interested in a case and they have grounds to suspect that the target is involved in money laundering or terrorist financing, for example, they can submit records to FINTRAC, but then FINTRAC makes its own analysis, and if it meets thresholds that are legislated, there will be a disclosure. So this is not like...
then we'll look at it from the opposite side then. If you're in the national defense and you have to wait for some other agency to tell you that there might be a threat to your national security, and you can't ask for that information because you don't really know anything really about that, how do you then, and FINTRAC's not really aware of perhaps it might be a national security threat, how do you actually then ensure that there's a coordination between these two entities? Have we set up a way for the national defense to interact in some way with FINTRAC?
Do they have a person?
There are mechanisms in place from an administrative point of view to govern the exchange of information, but as I say, it's mostly one way. It's FINTRAC, when it meets thresholds, it's going to be able to disclose to the recipients. At the same time, FINTRAC maintains ongoing discussions, like with, in a calibrated manner, with disclosure recipients to better understand the environment they're operating in and understanding the priorities. So therefore, when it comes across as part of its analytical work, information that is relevant to them, it is able to make that judgment call.
So, for instance, we talk a lot, we'll just go to another thing in the Act here, and I'm sorry to waste everyone's time, I hope I'm not boring anyone. Thanks. But, this is often, I've noticed there's quite a number of mentions, that issue or the sell of money orders or redeem them from the public. So this is to ensure that, for instance, monies aren't transferred illegally or to finance terrorist operations. But let's say we have the Canadian Forces in operations in some country, in perhaps Africa, and someone has an unregulated thing, a corporation under a provincial jurisdiction, and they're doing money transfers. And how does FINTRAC then ensure that the national defense is aware that monies might be flowing into the zone of operations where they're operating, so that they're aware that maybe arms are being purchased that could be used against Canadians? I know it's a thing outside of the finance thing, but the reason I'm asking is because I think it's, I'd like to see how these moving parts, like, because we're about to pass this legislation, how are these moving parts going to work together?
So as a general rule, any financial transaction, any electronic fund transfer out of the country over $10,000 would have to be reported to FINTRAC.
We always do 9,000, so.
So you can do that under that. Now, if you have a series of transactions, any sort of money remittance business doesn't have to wait until the $10,000 threshold is met. They could say, wow, there's a lot of transactions going to that little town, and I know that's a bit of a war zone. That doesn't look right. So they can then say, that to me is a suspicious transaction, and I need to report that. So just because we have the $10,000 threshold doesn't mean that they're not reporting you. And then, so they would put that information together and send it to FINTRAC and say, there's all of these little things going to this little town, and you might want to look into that. And so FINTRAC has the ability, and they also work with, have the ability to disclose the information to their national security partners as well. And if they felt that there was an issue, that they knew the Canadian Forces were there and that the money was going into this region and that it looked suspicious in the eyes of the money transmittal business or whoever would be sending the money, they would be then in a position to share that information if it met the two tests.
So now I'd like to take one final.
Be good if that's one final.
One final thing, but I guess I'm interested in the additional cost that it would endear to corporate or small corporations under provincial jurisdiction. Because let's say you're from the Philippines and you're working hard, and all of a sudden you have to have, I believe there's additional reporting requirements with FINTRAC, correct?
So, well, those reporting requirements already exist.
Oh, they already exist. So there's no additional requirements for these unregulated.
Well, the unregulated trusts would be a new one, but it's in any type of new legislation or regulation in this area, we have to balance the national security interest against the.
So what would be the additional cost then on the ground for some of these corporations? Because some of them are probably very small because they're not under federal jurisdiction, they're under provincial jurisdiction. And what would be then the final, these trusts, what would be the final costs on the ground for someone, and what would be the impact?
I think what you are referring to, and when you allusion to the Philippines, I think you mean money service businesses where people in Canada may remit money abroad and use these services for that. So we are not increasing reporting requirements on these types of businesses under this legislation. The change that we are doing for trust is only the vast majority of trusts in Canada. Trust companies are already regulated under the Act. We only expanded, clarifying that we're also covering a certain type of trust that operate in a different way. And
could you give a final example of that type of trust?
So
and what they do.
So as Lisa indicated, like under the Act, the current wording indicates that trusts that are regulated in Canada are covered by the obligations of the Act, but through exchanges with the industry and international assessments, like questions were raised as to whether trusts that are incorporated in Canada but not regulated in Canada, whether they were covered by the legislation. So here we're clarifying that they are indeed covered by the legislation.
Okay, thank you all. If you're still not clear, we can come back to you in a moment, but we need to stay on the Budget Implementation Act if we can. Mr. Sabara and then Mr. Fergus.
Actually, I'll pass for now. Thank you, sir.
Fergus.
Alors, ma question, merci beaucoup et bienvenue.
Thank you very much and welcome to the House of Commons. My question will go back to the questions asked by my colleague, Mr. Willett, concerning the frequency of communications between FINTRAC and the Defense Department or the Canadian Forces. What would be the period or the frequency of communications between FINTRAC and the department or the forces when it comes to information sharing?
Pretty hard to tell how often they would have information that would meet the two tests. I would think as a sort of context-setting piece, they would probably have an initial discussion to sort of set out what are your concerns and what are the things that you would be, what kind of information would be useful to you. But it's very hard to tell at this point without.
Alors, quelle est la période de quelle est la fréquence actuelle maintenant?
What is the current frequency? How often? There isn't? There aren't any? No. Given that these are two federal institutions, there might be contact, but to the extent that the Department of National Defense or the forces, given that they don't currently receive information under the Act, there's no formal communication process that's protected by the law. Do you think that if there's information that you believe is important to be shared, is there a certain delay before that information would come to your attention? Would you get in touch with those groups within a certain period of time, or? I think that normally when they have information, they share that information as soon as possible. All right, thank you.
One question on this, and that would be along the lines from the public. What is the there is privacy issues involved here. So what's the protective oversight on privacy issues?
So the legislation is a very careful balance. The Proceeds of Crime, Money Laundering, Terrorist Financing Act was designed as a very careful balance between national security, charter rights, and privacy. And the agency has as one of its primary objectives the protection of personal information, and they are subject to regular audits by the Privacy Commissioner to make sure that they are keeping those commitments.
Okay, no further questions on Division 19. Thank you both for your presentation and answering questions. Then we'll turn to just
Sorry, Chair,
hold on
just one final
sec.
question. Is this?
I thought we got you out of here before Olette gets started again.
With the provisions with the Canadian Forces, will this be subject to the council? What's that term when you have a can't remember something? But the oversight committee for
the new parliamentary oversight committee.
Yes, for the national security.
Oui, ça ferait partie.
Yes, that would be part of that, yes.
Okay, thank you again. Better get out fast before Robert starts again. Division 5, payment to the Part 4, Division 5, payment to the Canadian Institute for Advanced Research. Miss McDermott, sorry. Ms. McDermott is Director General, Program Coordination Branch, Innovation, Science and Economic Development, Canada. Yes?
So you passed over shared services. Is that because it's gone to another committee?
Yeah, this Division 4 has been firmed out for another committee and we haven't heard back.
Okay.
There's 5 that have been firmed out, so Division 4 is one of them. And we'll know tomorrow whether they're going to send them back to us.
You have heard from a couple, have you not?
We've heard from one.
One? Okay, so we will just do that one then.
We'll do that one. It seems the other 4 committees now, where one was reluctant, they may be going to take it on and then come back to us. And I think on the infrastructure bank one, we're going to deal with it too, as well as the other committee. Okay. Ms. McDermott, the floor is yours. Thank you.
Thank you very much. So this next clause is fairly straightforward. It provides authority for the Minister of Industry to make a payment of up to $125 million out of the Consolidated Revenue Fund to the Canadian Institute for Advanced Research, commonly known as CFAR, for the purpose of establishing a pan-Canadian artificial intelligence strategy. The measures are designed to strengthen Canada's position as a world leader in artificial intelligence research and lay the scientific foundation upon which to build national leadership in artificial intelligence innovation.
Okay. Mr. Dussault.
Merci. Merci.
Thank you, and thank you for being here with us. As you know, this is cut and paste from Bill C-43. But that's not really my question, to know why this was integrated in Bill C-44, but rather I'd like to know why you decided to do this through legislative means instead of through credits. The usual means is quicker, and if it's a government priority to get this $125 million through, it would have been in the main estimates that have already been passed. So can you explain why you decided to move through put this through legislative means and ask this committee and Parliament to pass this part of the bill when it could have already been done another way rather? Well,
sure you are aware you don't have to get into some of the political decisions that were made. They would be better asked to the minister on Monday, but you're certainly welcome to answer that question if you think you can.
Merci de l'introduction. Peut-être je vais...
Thank you. I would maybe just say that I think it's clear that this is a priority for the government, and sometimes a government may use legislation to give a higher profile to some measures. that it wishes to emphasize. Also, there are consequences in terms of the speed. Putting this in a bill, this sort of measure, sometimes it moves things along quicker, and it allows us to enter into an agreement with the recipient, in this case with CFAR. So there are various reasons why this means might be useful to move forward with such a measure. So it's generally speaking to increase the profile of the measure. Well, that can be a factor, yes. All right. I'll maybe reserve my comments, Mr. Speaker, for the Mr. Chair, for the Minister. But I think that if we want to increase the profile and we want the money, if we'd rather the money had gotten to the recipients quicker, if we'd put it in the estimates, it would have gone faster.
Thank you. I just have one question in regards to how this strategy will retain and attract the top academic talent, or how this differs from other initiatives to attract top talent, especially in AI. Could you maybe elaborate a little bit more on that?
Sure. So there are a number of measures that the federal government has taken in the past, and programs, for example, run by granting councils that support talent, including Canada Research Chairs. What's a bit special about this type of funding is it is specifically to promote talent development in AI. So a portion of the funding, in fact, a fairly large portion of the funding, will go to support chairs. And the funding is both to support the recruitment of chairs from outside Canada and in retaining top quality researchers in Canada, so that they remain and continue to have the ability to work to continue their research.
Thank you. Sorry, I just have a follow-up based on that. Will the research or the attraction of this talent also not deal with policy around AI, and not just, obviously the technologies, but for example, the Council of Europe had this specific AI conversation, and it was kind of astonishing to see the policy fears from some members and some states. And so I'm just curious that as technology changes, we're also going to need policy expertise or experts that are looking at policies around the world. Will that be a feature of this, or is this strictly on kind of the development of technologies and research in that field?
So thank you for the question. Yes, it's certainly the technology is associated with being a very disruptive technology and having potentially disruptive effects on society and implications for policy. And indeed, some of the funding that's being provided to CFAR will be used to support research into ethical, legal, public policy considerations associated with artificial intelligence.
Thank you.
Thank you, Mr. Fergus.
Merci beaucoup d'être ici. Puis,
Thank you very much for being here, and I'm very happy that the government has invested this money. And given that this is a one-time payment, do you expect that after 2018 that there will be a need to continue to find other sums of money to continue the work on this initiative? Well, we expect that this investment will last 5 years. That's set out in the plan. As mentioned, there are other tools that exist to fund research and support research. So it will be the future that will determine if it will be important to make more investments or not. But for the moment, this is an investment, as you mentioned, that is a lump sum investment, but it will last for several years. If I may, Mr. Speaker, or Mr. Chair, rather, do you believe that this will be like the model for the Canadian Innovation Fund, for example, or the foundation, which was created 20 years ago, where there was a one-time investment, but where we realized fairly quickly that to maintain the value of that investment, it was important to make periodic investments on an ongoing basis. I would imagine it would be the same thing with this initiative on AI. Well, it's difficult to tell what the future may hold, but I think that there can be no doubt that the investments that have just been made or that are being made are good investments.
Mr. Ouellette.
Thank you. I'm a little bit interested by CIFAR. So they have 404 researchers in 16 countries. So do you know what some of the requirements will be for CIFAR, the Canadian Institute of, sorry, I'm looking for the name.
For advanced research? Yep.
Advanced research, yes. Do you know what the requirements will be for that funding? Because, you know, at the end of the day, you know, if I look at some of their things, they could fund people outside of the country.
So thank you for the question. CIFAR does actually receive funds from the federal government to support research networks. Generally, they fund Canadian researchers to participate in international networks. So some of the funding is received by researchers outside of Canada. Very excellence focused. That's their normal program of research. The investment in artificial intelligence is actually a separate agreement with CIFAR, and we have put in place a number of sort of quite specific requirements in terms of how that funding is spent. And I'm just wanting to make sure I'm accurate, but I believe all of the funds will be spent in Canada by Canadian institutions, to my knowledge. Yeah.
So what's the difference between CIFAR and the Tri-Council? Why, could you give us a bit of a rationale over the difference between the two and why one is perhaps more flexible or less flexible than the other?
Yeah, they have they would say they have complementary purposes. The Tri-Councils have large budgets, relatively large budgets. The three councils together fund about $3 billion a year of research, talent development, scholarships, translational support, whereas CIFAR's budget is, and the federal government provides them about $5 million a year. In the last budget, that was it's proposed to be increased to $7 million a year, and that would represent about a third to a quarter of its total support. It has funding from other levels of government as well in the private sector. But CIFAR's work, it's very elite focused. The councils tend to focus on a range of researchers, all excellence based, but emerging researchers and a different sort of toolkit. CIFAR's research tends to be in support of highly elite research. It's about getting Canadians to participate in international research networks of very high level. And so it's about raising the game for top Canadian researchers, but also contributing to knowledge that will benefit Canadians and, in fact, the world. So it's just a slightly different set of activities.
And just one short final question. So we provide $125 million to CIFAR. Who owns the property rights to the knowledge produced? Is it public or is it private?
So it's actually a complicated question. We have given CIFAR the requirement to develop an intellectual property policy in consultation with the nodes who will be in recipient and the recipient institutions that will be recipients of this federal funding. So as you may be aware, institutions across the country have their own individual IP policies. And there's actually evidence to support many different types of strategies. It's also notable that in terms of what the kind of research tells us about intellectual property policies is that often they would differ by sector in industry, and that depending on the stage of the research, whether it's very early stage or late stage, different types of intellectual property protection makes sense. So it's actually a pretty complicated task that we've given to CFAR to work out an intellectual property policy that is going to be optimal for managing this large sum of money.
So potentially Canada could have property rights over some of the knowledge produced, the Canadian government, or the Queen.
Or in many cases it would be individual universities that house the researchers that are doing some of this work. So that is many universities have those kinds of policies. Most of those policies are designed to facilitate some form of ultimately some form of commercialization. Usually there's mechanisms for that property to be transferred or licensed out and used. But obviously, everyone, the government is very concerned about making sure that the benefits of this technology are, support Canadians. At the same time, I think there's interest in making sure that the research is advanced and not hampered by those kinds of policies.
Thank you all, and thank you, Ms. McDermott, for your in-depth answers. We will now turn to Part 4, Division 6. And we have representatives from the Employment and Social Development Canada on financial assistance for students. Mr. Rahman is the Director General, Canada Student Loans Program. Mr. Cote is Director Policy and Research, Canada Student Loans Program. Mr. Moore is Director Program Design, Canada Education Savings Program, and Ms. Nagy is Senior Strategic Planning Advisor, Canada Education Savings Program. Welcome, and I'm not sure who is making the presentation. Mr. Rahman?
Thank you, Chair. Yes, I will. I'm from Canada Student Loans Program. I will cover Clause 116 that's related to Canada Student Financial Assistance Act, and then my colleagues from Canada Education Savings Program will cover Clauses 117 to 121. Those are related to Canada Education Savings Act. With respect to Clause 116, as I said, this is a proposed amendment to Canada Student Financial Assistance Act that currently limits who can be a qualifying student to Canadian citizens, permanent residents as defined in Section 2, Sub 1 of the Immigration and Refugee Protection Act, and protected persons within the meaning of Section 95, Sub 2 of that same Act. As a result, persons who are registered as Indians under the Indian Act but who are not Canadian citizens are not eligible for student financial assistance under the Canada Student Financial Assistance Act. Amendments to this Act will be introduced to provide that persons registered as Indians under the Indian Act will be eligible for student financial assistance regardless of their citizenship. That's Clause 116. I will now pass over to my colleagues from Education Savings Program.
Moore, the floor is yours.
Thank you very much. So I'll start and discuss 117 to 121 of Part 4, Division 6. By way of context, I'd like to note the following. Canadians use registered education savings plans, RESPs, to save for a child's post-secondary education. RESPs grow tax-free until they're withheld to pay for full-time or part-time education at a community college, university, CEGEP, trade school, or apprenticeship program. And the Government of Canada, we offer two different education savings incentives, the Canada Education Savings Grant, which is available for all Canadians, and it's based on contributions. In addition, low and middle income Canadians get an additional 10 or 20% based on contributions, and the Canada Learning Bond, which is available for low-income Canadians, and no personal contributions are required. So under the current legislation, requests for the Canada Learning Bond and the additional amount of the Canada Education Savings Grant submitted by anyone other than the primary caregiver, the person principally responsible for the care of the child, are declined. So the Canada Education Savings Act, which governs the administration of these education savings incentives, is being amended to permit the primary caregiver's cohabiting spouse or common law partner to apply for the Canada Learning Bond and the additional amount of the grant on the child's behalf. It's anticipated that by allowing the spouse or the common law partner of the primary caregiver to also apply for these education savings incentives on behalf of the beneficiary, fewer education savings incentives requests will be declined, and there'll be a resulting increase in the take-up of the Canada Learning Bond. And it should be noted that the eligibility requirements for the Canada Learning Bond and the additional amount of the Canada Education Savings Grants are not being changed.
Thank you both. We'll start with Mr. Sabara.
With regards to the program, the RESP program, Canada Learning Bond and Canada Education Savings Grant, if you can just kind of comment the uptake on that by Canadians, by Canadian families. I know I have an RESP program for my two daughters, and how any of these changes here may expand the participation.
Right, so for the Canada Education Savings Grant, the take-up rate is 50.1% based on 2015. And for the Canada Learning Bond, it's 33.1%. So by amending the legislation, we anticipate that we could increase the take-up by approximately 54,000 new RESPs, roughly 9,000 Canada Learning Bond, and 46,000 additional amounts of the Canada Education Savings Grant.
Thank you.
Any more questions over here? On clause 116, it's noted that this provision will come into force on August 1st, 2018. It's clause 121.1, I guess. Why the delay? If it's going to improve the ability to gain an education, why not bring it in this year?
So the way the student loans program works is that it is delivered through our provincial and territorial partners, and the student loan applications will have to be modified slightly, and that can't quite be done until the next school year.
Yes, so it's a matter of consultation. And is there any more questions on this section, members, or anything else you want to add? Mr. Dussault.
I'm just trying to understand your enlarging or increasing for RESPs. You're increasing it so now a common law spouse can open an account on behalf of the child. Does that mean that the child could end up with two accounts for one child if there are two people who make the request?
For the Canada Education Savings Grant, there can be multiple accounts open because it could be a grandparents, aunts, uncles, spouses, but the amount of the grant it doesn't multiply. There's only a certain amount for each child, and we monitor that through the systems we have. For the Canada Learning Bond, either the primary caregiver or the cohabiting spouse or common law partner will have to indicate one RESP that the Canada Learning Bond can go into. So a little bit of different rules for both, but we make sure that that we do not overpay the amounts of the grant or the bond.
Okay, that's it. Satisfied? Okay, thank you folks for your presentations and answering questions. We'll now turn to Part 4, Division 8, the Investment Canada Act. And we have with us from Innovation, Science and Economic Development Canada, Patricia Brady, Director General, Investment Review Branch, Jonathan D. Wolf, who's the Director, Policy and Outreach, Investment Review Branch. So welcome, Patricia and Jonathan. Who is going to start?
I'll start. Thank you.
Good afternoon. So we're here to speak to Division 8 of Part 4, which proposes 2 changes to the Investment Canada Act. The first change in Clause 192 is to raise the dollar value threshold that triggers the requirement for a net benefit review of a foreign acquisition of control of a Canadian business to $1 billion. Currently, an acquisition by a non-Canadian of a Canadian business that's valued at or above $800 million must be reviewed under the Investment Canada Act for its net benefit to Canada and approved by the Minister of Innovation, Science and Economic Development before it's allowed to go ahead. There's a schedule in the Act currently for this threshold to rise to $1 billion on April 24th, 2019, roughly 2 years from now. The amendment in Clause 192 would accelerate that increase, so that the threshold would move to $1 billion upon coming into force of the Budget Implementation Act. So that would be 2 years ahead of the already planned schedule. The higher $1 billion threshold will only apply to investments by private sector investors. There's a lower threshold in the Act for investments by state-owned enterprises. That threshold right now is $379 million, and this amendment will not change that threshold. In addition, the amendment won't change the government's ability to review investments for national security concerns. Any investment by a non-Canadian now can be reviewed under the Act for national security concerns. There's no dollar value threshold for that review, and this amendment would not change that. The second proposed change to the Investment Canada Act is in Clause 193, and that's to require annual reporting on the administration of the national security review provisions in the ICA. So currently, the Minister of Innovation, Science and Economic Development is required to report annually on the administration of the net benefit review provisions, but the national security review provisions are actually exempt from that reporting requirement explicitly. This amendment would remove that exemption to require annual reporting on how national security review provisions have been used. So that's an overview of the changes in Clause 192 and 193, and we're happy to answer any questions.
Okay, we'll start with Mr. Dussault.
Merci, Monsieur le Président. Et, comme...
Thank you, Chair. And as you know, you mentioned in the current version, because the Act has not been passed yet, there is we go from 600 to 800 million to 1 billion, and now you're saying that it would go straight to 1 billion. I haven't looked into the details, but do you have the same ladder? Will it continue to increase? Or will it stop at 1 billion? It's going to stay at 1 billion. However, there is a formula in the Act currently which provides that the threshold will increase with growth in GDP, annual inflation.
It happens every year based on inflation, but it's a smaller increase. So for example, last year the state-owned enterprise threshold was 375 million. This year, according to the formula for the increase in GDP, it went up to 379 million.
Mais sur les entreprises
And for the OMC investors, the 1 billion will stay at 1 billion. Or will that go up with inflation? Yes, that will go up with inflation. But there are no plans to increase it otherwise. And I also have a question concerning transitional measures, if transitional measures have been put in place. In other words, right now, if an investor is interested in a Quebec business and wants to buy it, and let's say that it's above 600 million, let's say that it's valued at 700 million today, and after the passage of this bill, this would go up to 1 billion. So if that happens, I'd imagine good lawyers would tell them to hold off on that until after the bill has been passed. So are there transitional measures if they're for cases where negotiations are already underway?
The Act. So right now, it's actually, the threshold is 800 million. J'ai entendu 600 milliards, mais c'est 800 milliards. Alors, for applications that have already been filed today, so there's an application for review filed, and that's based on the current enterprise value of the Canadian business that is to be acquired. For applications that are filed today, when these amendments come into force, if the enterprise value is below $1 billion, the application, and a decision has not yet been made, then the application would be deemed not to have been filed. But essentially it will require a recalculation at the time of these amendments coming into force of what the enterprise value is, which for public companies is based on market capitalization. They'll do that recalculation. If at that time the Canadian business is valued at more than $1 billion, then of course it would be subject to review. If it's less than $1 billion, it would not be subject to review.
Okay, puis ma dernière question, c'est peut-être pour...
And my final question would be to give you an opportunity to answer certain critics of this measure who are afraid for headquarters in Canada, and I've heard a lot about this in Quebec, but I believe that the same concerns exist elsewhere. So what would you say to this concern from Canadian citizens who fear that business headquarters will disappear, will leave for foreign countries? Now that this is going from 800 million to $1 billion, that could accelerate that loss of head offices from Canada?
Of those concerns. But what I would say is that Canada's policy for the last number of years has been to welcome foreign investment because of the benefits in general that it brings in terms of higher paying jobs, innovation, technology and management expertise spillover, et cetera. So there have been a number of initiatives over the past many number of years to increase foreign investment to Canada because of those investments, and this is, following on that policy position.
Thank you, Mr. Dussault. Mr. Deltel.
Chair, Madame, Monsieur, soyez les bienvenus à votre chambre.
Welcome to your House of Commons.
Security. In this omnibus bill, we make some change on this issue. I would like to hear you about those changes.
So the change related to the national security review provisions is just to require annual reporting on the administration of those provisions by the Minister of Innovation, Science and Economic Development. Right now, there's very little public information about national security reviews other than what's in the law, and so this change would require annual reporting on how the provisions have been used each year. We also issued guidelines. That was not part of a legislative amendment, but those guidelines were issued in December of 2016 that provided more guidance, practical guidance to investors and Canadians on the national security review process. And this is part of that transparency-related initiative.
Personne, Monsieur le Président, qui est contre la transparence.
Mr. Chair, there's nobody who's against transparency, but when it comes to national security, that's something else entirely. What studies did your department or that the Minister or the Department of Finance undertook that led to this decision?
Just to be clear on what would be actually reported in the annual report, it would be high-level information on the number of reviews that have been conducted. It would not give information on the particular investments involved, both to protect national security and to protect confidentiality. But numbers of reviews would be provided without specific information on the investor or the national security concern, and the outcomes of those reviews would be provided at a high level. So this was actually done, there's authority for this under the Act to be done voluntarily, but it's not required. So last summer in the annual report, the government issued that information on past reviews. So it became public in the summer that 8 formal national security reviews have been conducted under the Investment Canada Act, and then the outcomes of those reviews at a high level were also provided. So in 5 instances, the investments were either blocked or divestiture was ordered, and in 2 instances, the investments were allowed with conditions. So it would be that type of reporting that would be envisioned going forward, always mindful of the need to obviously not disclose information that would compromise national security or confidentiality.
As we all recognize when we talk about national security, we're working on a thin ice. Do you have a clear definition in your department about what is national security?
The Investment Canada Act does not define national security. It's left fairly open-ended to recognize the fact that threats to national security can evolve over time, and so to provide discretion to, and it's actually, Cabinet is the decision maker on the national security review portion of the Act, so it would be to provide the flexibility to Cabinet to recognize that national security threats may evolve. It's hard to fix them in time.
Do I understand well that the last call will be made by the Cabinet?
That's right. Cabinet has the authority to make the decision on whether or not to order a formal review, and then has the authority to take any measures. The language in the Act is any measures that it considers advisable following a review to protect national security.
Does it register somewhere instead of the Cabinet, le résumé des rencontres du Cabinet, mais do we when the Cabinet table a decision, this is national security and this is not? Can we find it, not daily, but we will not have to wait 40 years, I think it's 40 years before we can know what has been said in the Cabinet?
Well, we would never be able to disclose what was said in Cabinet because it's a Cabinet competence. And the annual reporting would be done annually on the numbers of reviews, but certainly not the details of Cabinet's decisions.
Thank you.
And that report is tabled with who? Is it with the minister?
It's the Minister of Innovation who has the requirement under the Act to make it public. So the way that we do that is we put it on our website.
Okay, thank you. And how, I didn't catch the number. How many reviews was there last year?
Not last year, sorry, I wasn't clear about that. So from 2009, when the National Security Review provisions actually came into force, until 2015, there had been 8 over that total period. And going forward, we would report on a yearly basis.
Mr. Fergus and then Mr. Ouellette.
First, just a statement. I think that the provisions in this amendment, I think this is a good amendment. I think this reflects the economic transactions, the commercial transaction which take place in an economy with a value of over $2 trillion. I think it's perfectly normal that we should be able to review transactions which are worth $1 billion. So that's my statement. Ms. Brady, we've had the opportunity to work together. Just a little question concerning transparency, and for my colleagues around the table, could you please specify how many reviews were completed in 2015 and 2016, not just since 2009, but recently? Well, reviews, net benefit reviews, or of national security? The net benefit. Yes, net benefit. Well, in 2015 rather, I think that there were 15. That's in our annual report.
Years, there have been 28 acquisitions of control that were over $800 million, which is the current threshold. And we looked at the number of those that were over $1 billion, and there were 20 that were over $1 billion. So based on historical numbers, you would see that I guess if the threshold had been $1 billion, then there would be about a third less reviews. But of course, we can't predict the number and values of investments, of future investments. But to give, by way of example, that would be the impact.
Mr. Ouellette. Go ahead, Robert.
Does Greg have any more questions?
No, he's done.
Okay. I'd just like to get a better idea or a handle of the evolution of the threshold. I was just wondering how long has the threshold existed in legislation, and if you have any stats that you could provide the committee in the future, perhaps tomorrow or the next day, where we can actually, I could see the evolution of the amount required. And I'd find that really very interesting, and give a good consideration about where we're going.
Sure. So on the evolution of the threshold, The Investment Canada Act in its current incarnation has been around since 1985. Jonathan's more of a historian on this than I am, and so I can go as far back as 2009, when the scheduled increase was first implemented. So in 2009, the threshold was, or in 2008 rather, the threshold was $275 million. At that point, the Competition Policy Review Panel, which is an expert panel charged with reviewing all of Canada's competition laws and frameworks with a view to making recommendations to make Canada more globally competitive. So at that time, the Competition Policy Review Panel did work and recommended that the threshold in the Investment Canada Act be increased from then around 295, I've been corrected, 295 million to $1 billion. Its recommendation was that that happen immediately, and that was based on its consultations across country and economic studies, et cetera, that assessed that Canada may be putting itself at a disadvantage in competing for foreign direct investment because, one, we have a net benefit review, and because the threshold was relatively low compared to the value of our businesses at the time. And so the recommendation was made then, and legislation was actually passed in 2010 to introduce this scheduled increase to $1 billion. And so the policy then was to, again, remove, a regulatory barrier for smaller transactions and focus net benefit reviews on those transactions that would be the most significant to Canada's modern economy. And so that was put in train then for those reasons, and then the initiative today is just to accelerate that final step in the increase to $1 billion as part of broader initiatives, some of which are in this budget implementation bill, to increase foreign investment and attract more foreign investment to Canada.
It took a decade, but you're there. Thanks.
That it? Then thank you both for your presentation, and we'll turn to thank you again, Mr. DeWolf, Ms. Brady. Turning then to Part 4, Division 9, Funding for Home Care Services and Mental Health from the Department from Health Canada. We have Ms. Boissin. And from the Finance Canada, we have Mr. Raja Bali. Might not have that quite right.
I think it's perfectly fine.
Okay. Whoever wants to begin, the floor is yours. And committee members, we are in Part 4, Division 9.
Thank you, Mr. Chair. So Part 4, Division 9 relates to the government's commitment in Budget 2017 to work with provinces and territories to strengthen the healthcare system, to adapt and innovate and address new challenges. So it confirms the offer that was tabled by the federal government on December 19th, 2016, to provide $11.5 billion over 10 years to the province to support key priorities under a new health accord, including $11 billion to be provided directly to the provinces and territories to support improvements for mental health and home care services. So this Clause 195 outlines the authorities and the conditions to flow funds for the first year of this $11 billion commitment. So that's in 2017-18 to provinces and territories as an immediate down payment on investments in home care and mental health. So that's $200 million for home care services and $100 million for mental health services, and those would be allocated on an equal per capita basis. So as set out in the proposed amendment, a province or territory will receive its share of this funding in 27-18 if the Federal Minister of Health notifies the Minister of Finance before December 15th, 2017, that in her opinion, that province or territory has accepted the federal proposal to strengthen healthcare that was tabled at the Finance and Health Ministers meeting on December 19th, 2016. So this December proposal envisaged a pan-Canadian approach and that provinces and territories would work with the federal government to determine how to measure and report on results and performance to improve these services to Canadians. And the Minister of Health is now engaging with her provincial and territorial colleagues on the details of how this future funding would flow and working with them to develop a multilateral framework for the 10 years of funding, which would include commitments to develop metrics and report to citizens, as well as outline their key priorities for action. So this multilateral framework would then be used as the basis for individual bilateral agreements with each of the provinces and territories for funding for the next 9 years. Happy to have taken your questions.
Okay, we're ready to roll. Mr. Sabara.
Thank you, Mr. Chair. Good afternoon. Earlier today, I had the privilege of speaking on Bill C-44 in the House and spoke about the agreement that was reached by the Minister of Health to deliver health care dollars and also funds for mental health care or mental health to the province of Ontario for a 10-year commitment, which I'm quite proud to say that was signed and quite pleased to see occur. But I'm just curious in terms of the accountability mechanisms such as reporting requirements that have been built into bilateral healthcare agreements. Can you comment to any of such with agreements with the provinces, of course?
Well, the minister has just started discussions now, so we're engaging with the provinces and territories on what the multilateral framework would look like. So we're looking at first a pan-Canadian approach that would have common priorities and a commitment from all the provinces and territories that they would work with us to develop indicators. And from there, then would flow bilateral funding agreements that would include the specific indicators that they would report on. So the provinces are at different stages in terms of where they're at in delivering mental health and home care services. And in some cases, we don't have pan-Canadian data yet. So those indicators need to be developed in collaboration.
Okay. Thank you, Mr. Chair. I'll leave my questioning there.
Is there any further questioning? Mr. Dussault.
Merci, Monsieur le Président. Merci pour votre...
Thank you, Chair, and thank you for your presentation today. I see in Section 9, Division 9, there's a formula to determine the amount which is allocated to each province for home care and for mental health services. Can you determine now the total amount which is being requested for, the total amount which will be allocated under this formula for the year that is coming?
That's actually provided in the legislation actually indicates sort of how it would be calculated for each province territory. I don't have the numbers in front of me, but that formula, then legislation actually illustrates how that's actually going to be calculated.
Okay. Est-ce que c'est possible de trouver ces...
Would it be possible to find those amounts somewhere in the Act?
Is in the Act for each province territory, so it's just a prorated share of the population per province, as published by StatsCan on their website, relative to the amount for home care mental health funding.
Okay. Ça s'applique juste à l'année prochaine.
Just applies to next year, not this year. Yes.
Not the balance of the remaining 9.
Pour justement le temps qui vient, les 9 années suivantes.
And for the following 9 years, I would imagine that there are negotiations that are underway to attempt to come up with a long-term agreement, not just 1 year at a time.
So she was indicating that there's this bilateral agreement that's going to be established. That being said, the press releases that have been issued for each of the 12 jurisdictions that have accepted the federal offer and the global amount that is provided to each PT or expected to provide each PT is actually spelled out on the Health Canada website.
Puis sinon, disons que le Parlement approuve ces...
If Parliament approves this spending for home care and mental health care, how, as parliamentarians, are we going to be able to ensure that the money that is allocated to each province, for example, in Quebec, if we use your formula, A times B divided by C, is there a means for us as parliamentarians to know the exact amount of money for, say, 2017-18, and to know if the money has indeed been spent for home care and mental health care? Do you mean in the bilateral agreements? Well, is there a mechanism an accountability mechanism to ensure that if we send, I don't know what the sums are, but let's say we send $500 million to the province of Quebec, do we have a mechanism to ensure that that $500 million, that all of it was spent on home care and mental health care? Well, the bilateral agreements are still being negotiated with the provinces and territories, but our objective is to have mechanisms in place to be able to report back to Canadians. For example, to ask the provinces to publish their bilateral agreements with us on the website. So certainly the bilateral agreements will include the amounts that the provinces will receive for each year. So then Canadians will be able to see exactly what those amounts are.
Show up in the public account documents, would it not? The public accounts, the figures would be available in the public accounts documents after the fact.
Mm-hmm. So in the context of transfers, because it's a legislative transfer, I'd have to verify, but that, yes, that would be my expectation, yes.
Mr. Desault?
Ouais, sinon, on l'a suivi sur cette question.
Well, otherwise, to follow up on this question, what I'd like to know is, have you done a constitutional analysis of this aspect of federal spending in healthcare when that money is directed to specific areas? Is it possible for the federal government to do this? Because we're going to be asked to pass this bill, and we want to ensure that this is constitutional, that if we say that the federal government is going to be spending X amount of money, I don't have numbers in front of me, but if we're going to be spending X amount in home care, is that constitutional? Does the federal government have the right to, we have the right to say, do we have the right to say you're going to spend X amount on a specific part of your healthcare system? So I just want to know if we can be reassured on that, because obviously this is something that's being raised by the provinces, and there was reticence, I'm sure you know, in the negotiations, given that the federal government wanted to decide how this money was going to be spent. And that could be seen as an infringement on the rights of the provinces to decide how they want to spend on healthcare. Can you reassure the committee that that's not the case?
There was, we did involve, of course, the Constitutional Law Office of DOJ. I can't remember, I don't know the proper name, so I apologize. But that being said, all the provinces, well, not all the provinces, 12 of the province territories did accept, including Quebec. Of course, in the context of the Quebec press release, I believe, and I don't have it in front of me, so I apologize, it actually did talk about the respecting the principles of the asymmetrical sort of agreement that was in place in 2004.
Vous êtes bien à l'aise de nous rassurer.
So you feel comfortable saying us that there won't be any constitutional problems if we pass this bill?
Pour moi, ça fait le tour, Monsieur le Président.
That covers it for me, Mr. Chair. Thank you.
Area. The formula A times B divided by C. There is a foundation amount for each province in both home care and mental health, correct? So that some of the smaller provinces, less population, don't get injured by just going to per capita?
So what do you mean by foundation amount? Do you mean like a base amount?
There's the base amount, 200 million in the case of home care and 100 million in the case of mental health. And so I just assume that's over the time frame.
So $200 million is over 1 year. So to be, I guess, more clear, maybe I wasn't clear before, the $200 million will be divided on an equal per capita basis. So, for example, if a smaller province had a smaller population, they would receive a smaller share of that $200 million.
Okay, so there isn't a foundation amount like there is on some of the infrastructure programming. That's and overall health care, I think there is as well in the formula.
So yeah, so the explanation you gave relative to infrastructure, yes, it doesn't exist.
Okay, that's fine. I think that's it for questions. Thank you both for your presentations. Then we will turn to Division 10, which is the Judges Act. While representatives are coming up, we just calculated here at the rate we're going to get through all the Part 4 divisions down to 21. It'll take us about another 7 hours to get there. And we have got an hour and 20 minutes plus another hour on Monday, so we get 2 hours and 20 minutes. So just to remind members, if we could keep questions on topic as brief as possible so that we can hopefully get through all Part 4 divisions. This is something we always run into, and it is a good way for members, I know, to gain information beyond the Act itself, but just keep time frames in mind if we could. So turning to Division 10, the Judges Act, Part 4, Division 10 Judges Act, we have from the Department of Justice Adair Crosby and Ms. Anna Decker. Ms. Crosby is Senior Counsel, Deputy Director, Judicial Affairs, Courts and Tribunal Policy, and Ms. Decker is Counsel, Judicial Affairs, Courts and Tribunal Policy. Floor is yours.
Thank you very much. I'm here to talk today about the Division 10 amendments that are proposed, and they touch on two aspects of the federal responsibility under Section 100 of the Constitution Act that Parliament must fix and provide the salaries and benefits of Superior Court judges. So there are two aspects. The first aspect is that many of these amendments represent the final step in the constitutional process required for setting judicial compensation, which includes review and non-binding recommendations by an independent, objective, and effective commission. So those recommendations were delivered to the Minister of Justice in June of 2016. The government publicly responded in October of 2016, and the proposed amendments would implement that public response through Judges Act amendments, and this is required in order to safeguard the principle of judicial independence, which includes financial security. And the second part of the amendments, which my colleague Adair will speak to, are Judges Act amendments that propose to increase the complement of Superior Court judges. So some of the highlights from the judicial salaries amendments are clauses 196 to 210 would simply update the judicial salaries in the Judges Act as of April 1, 2016, which is in keeping with the time frame of the Commission's recommendations. Clause 198 would increase the salary of the Chief Justice of the Court Martial Appeal Court of Canada to be equal to the salary of other Chief Justices of Superior Courts. And it would also propose to increase the salary payable to the prothonotarians of the federal court from 76% to 80% of the salary of a federal court judge. Clause 213 proposes to amend the start date of the next quadrennial commission and subsequent quadrennial commissions from October 1st to June 1st. Clauses 215 and 216 propose an annual allowance of $3,000 for the prothonotarians, and it also proposes reimbursement of 95% of the prothonotarians' representational expenses before the the quadrennial commission. Clauses 218 and 221 propose changes to certain Chief Justices and senior judges in recognition of their years of service for carrying out their managerial responsibilities. Clause 220 would extend existing removal allowances to the judge of the Supreme Court of Newfoundland and Labrador who is resident in Labrador in certain circumstances. Clauses 224 to 226 are technical amendments, for example, to correct discrepancies between French and English language of the provisions that govern the division of annuity and conjugal breakdown, and they would ensure that financial support orders can be enforced on all applicable Judges Act payments. And I'll turn it over to my colleague.
Thank you, Anna. So I will give you my abbreviated version. since time is of the essence today. So as Anna mentioned, this is the second element of Division 10, which essentially provides for the establishment of 27 new judicial positions in the superior trial and appellate courts across the country. These increases in the judicial complement are intended to address workload pressures facing many of the courts, including those arising as a result of the Supreme Court of Canada's decision in Jordan. The breakdown, if you refer to clause 208, you'll see the breakdown that there will be an increase of 11 judges to the Alberta Court of Queen's Bench and 1 judge to the Yukon Supreme Court. These amendments are to respond to needs that have to date been demonstrated. The balance of the amendments found in clause 211 authorizes the appointment, or rather the creation of a pool of judges, which would comprise 12 new judges that can be appointed to the provincial superior courts and 3 new judges to the provincial appellate superior courts. These 15 positions will basically be allocated across Canada to help ensure that needs in those jurisdictions are met. We are working right now with our colleagues in the various jurisdictions to develop the sort of objective data that will be necessary to demonstrate that there is a need there. And at that point, the appointments would be made. That's my short version. I'm happy to take questions.
Thank you both. Starting with Mr. Ouellette.
I don't know how many lawyers are here, but I really find it obscene the amount a judge makes. $314,000 a year. It's a king's ransom, and I'm actually disgusted to see it. I hope Ms. McLaughlin hears me, because I don't think it's fair in our Canadian society. The judges aren't even in the 1%. They're in the top, they're in the top 0.1% of people in Canada. And I don't think it's in our just society. That's something we should have happening. And I see judges are getting a raise. I noticed military personnel haven't received a raise in over 5 years. And yet judges continue to receive a raise. So anyways, that's my comment. That's all I have to say. Anyways, may they continue to be independent.
I know the folks here can't respond to that question. You've made your point, Mr. Ouellette. Was there anybody else on this, Mr. Vergas?
It's just a quick question. Among the new positions for judges at the Superior Court, is there an estimate of the number of Quebec judges who will be appointed? Or the number of positions available for Quebec? I'm sorry, I'll answer in English, but I do understand your question.
No positions have been formally allocated in the legislation. If you open up the Judges Act, what you will see is for every court a certain number of positions. The 15 pool positions are those which would be allocated to Quebec, some or all of them, depending on the need that Quebec is able to demonstrate. One thing I would like to point out is that there has been a lot of press about the number of vacancies in Quebec. In fact, as of last week, there's only 2 vacancies. The 8, we hear upwards of 14 or 16 vacancies. Those positions don't exist until this legislation has been passed. So there are 2 vacancies, and then there would be, of course, a maximum of 6 additional appointments the minister could make based on the additional positions that have been authorized in the provincial legislation.
So just for precision then, there are a number of positions there are 2 positions which are vacant in Quebec. We've just recently filled a number as well, but there's also the potential for another 6, an additional 6.
Is it 6 or 8? It might be 8.
I believe it's 8. That because the administration of justice is divided between the provinces and the federal government, so Quebec has created those positions in their provincial legislation where they constitute their courts, but the salaries have to be authorized through the Judges Act amendments, and that's what my colleague was talking about, where there will be objective analysis of the need, and they will demonstrate that, and then the pool positions could be allocated.
Okay, thank you.
Mr. Dussault.
Juste rapidement sur l'indexation.
Just quickly on the indexation, and thank you for joining us. The indexation under the pay index, the weekly average. Could you tell us what was the percentage of this index in recent years, and what does that represent? 0.1 or 2.3? What does that index look like?
So the most recent indexation was on April 1, 2017, and that was 0.4%. So the salaries would have increased by 0.4%. In recent years, I do have, for example, in 2016, it was 1.8%. Going back another year, 2.6, 1.8, 2.5, 2.5, 3.6. So it has ranged in the last several years from a high of 3.9 to a low of 0.4, which was the most recent.
Puis pourquoi vous je sais que c'est dans la loi sur les juges.
I know it's in the Judges Act, so maybe it's not necessarily in C44, but why do you use this index instead of another?
The IAI, the Industrial Aggregate Index, has been in place since 1981, and it was chosen. The issue is that in order to ensure independence and financial security, there had to be some kind of way to guard against erosion of salaries on the basis of inflation. So the IAI was chosen because at the time it was the same one that MP salaries were indexed against.
Fait que c'est dans le but, vous dites, de protéger l'indépendance qu'on.
Was it to protect the independence that this this index was chosen instead of, say, the consumer price index?
I can't speak to what was debated at the time, but they're protecting against erosion. That would have been one option, I'm sure. Maybe Adair has a greater historical memory of this.
Unfortunately, I do. The IAI at the time was picked because it actually reflects wages, and it was an attempt to provide an indicator that roughly approximated increases in wage levels, since this is a salary, this is an index that's based on salary. It's as simple as that. At the most recent commission, the government did attempt to assert that CPI would be a more appropriate guard against inflation than the IAI. The commission recommended against that and recommended that IAI be preserved. There's been a rough relationship over a number of years between the IAI and the CPI. Some years it's higher, some years it's lower, but if you look at the graph over time, it's roughly approximate. This year it was a loss for sure. CPI exceeded the IAI.
Okay. Well.
Okay, thank you all. Thank you very much for your presentation, Ms. Decker, Ms. Crosby. You're released, and we'll turn to Part 4, District 11, Support for Families, Benefits and Leaves, and from ESDC is from Economic and Social Development Canada. We have okay. We have Ms. Asterbas, who's the Director, Special Benefits, Employment Insurance Policy. Mr. Brown, who is Executive Director, Employment Insurance Policy, and Ms. Hill, who's Senior Director, Strategic Policy and Legislative Reform, Labor Program. I'm not sure who's making the presentation. Mr. Brown, the floor is yours.
Okay, thank you, Chair, for the introduction, and I'll get right into my opening remarks. Je vais parler des modifications.
I will speak about the proposed amendments to the Employment Insurance Act to offer more flexibility to parents and more inclusive benefits for caregivers.
Largest labor market program. The program provides temporary income support when workers lose their job through no fault of their own, known as regular benefits, and in specific situations that may occur over the course of one's working career, known as EI special benefits. EI special benefits play an important role in helping individuals balance work-life responsibilities. They include maternity, parental, and caregiving benefits, as well as sickness benefits. First introduced in 1971, the special benefits have evolved and expanded over time. In 2015-16, over 379,000 Canadians received maternity, parental, and caregiving benefits, representing a total of $3.8 billion. Budget 2017 introduces a number of changes to provide additional flexibility and support for families that I'll briefly outline. First, the bill introduces a new 15-week EI caregiving benefit. Eligible caregivers would be family members who are away from work to provide care for a critically ill adult, such as someone recovering from a serious accident or illness. And in the unfortunate event that a family member's condition gets worse and deteriorates to an end-of-life situation, caregivers would continue to be able to combine this new benefit with the existing compassionate care benefit. Secondly, the bill provides more flexibility for families by allowing any family member who is eligible for EI, as opposed to only parents, to access the existing 35 weeks of EI support to provide care for a critically ill child. Third, in order to enhance access to all EI caregiving benefits, medical doctors and nurse practitioners will be allowed to issue the required medical certificates. This measure will enhance access for Canadians and especially those living in rural or remote regions. And these measures related to caregiving are expected to benefit up to 24,000 families annually. The bill also introduces changes to EI parental and maternity benefits in order to offer both biological and adoptive parents more choice and flexibility according to their family needs. Fourth, the bill proposes new flexibility for parents welcoming a newborn or newly adopted child. Parents will have a choice to receive standard duration parental benefits as are currently provided that are up to 35 weeks, paid at 55% of the average weekly insurable income over a 12-month period, or to choose the extended duration parental benefits over 18 months. So that would be paid for up to 61 weeks at a lower benefit rate of 33%. And fifth, women will also have more flexibility to access EI maternity benefits as early as 12 weeks before the expected week of birth, as opposed to the current 8 weeks prior to the expected week of birth. Providing earlier access to maternity benefits will allow pregnant workers to better take into account their particular health and workplace circumstances. Taken together, these changes will have a positive impact on women in particular and offer them more choices. Indeed, in 2015, among recent mothers with insurable employment, 87% received maternity or parental benefits across Canada. The bill ensures that the same changes that apply to insured workers will also apply to self-employed workers who voluntarily participate in the EI program by paying premiums. The bill also adapts existing EI rules to clarify when and how EI special benefits can be combined together and over what period of time. These
proposed changes will have no direct repercussion on Quebec residents because the province currently offers maternity benefits and parental benefits and adoption benefits through the RQAP.
More flexible EI parental and more inclusive EI caregiving benefits represent an incremental cost of $886 million over 5 years and $205 million per year ongoing thereafter. As per the Employment Insurance Act, these costs will be charged to the EI operating account and recovered through EI premiums. All of these amendments would come into effect on the same day, later in the 2017-18 fiscal year. The exact timing is to be confirmed, and the date would be fixed by an order of the Governor and Council. Je passe maintenant la parole à ma collègue
Now cede the floor to my colleague Margaret Hill to talk about affected changes to the Canada Labour Code.
As Andrew mentioned, I'll speak briefly to the amendments that are proposed in the bill to Part 3 of the Canada Labour Code. Part 3 of the Code, as you may know, establishes minimum working conditions in federally regulated sectors, such as hours of work, annual vacations, and statutory leaves. Federally regulated sectors include about 6% of all Canadian employees in industries such as banking, transportation, as well as federal crown corporations and certain activities on First Nation reserves. Part 3 does not apply to the federal public service. In general, when amendments are made to the EI special benefits, corresponding amendments are made to the leaves under the Canada Labour Code. This is done to ensure that federally regulated employees have the right to take unpaid leave while they access the EI special benefits without fear of losing their jobs. Amendments are therefore being proposed in the bill to ensure that existing leave provisions under Part 3, specifically those related to maternity leave, parental leave, compassionate care leave, and leave related to critical illness, are fully aligned with the proposed changes to the EI special benefits. The overall cost to the labour program to implement the proposed changes to the code is expected to be modest, about $400,000, which would cover things such as training of labour program inspectors, the production of educational materials for employers and employees, and the development of supporting regulations and the monitoring of the impacts of the changes. Costs to employers are expected to be minimal and will depend on the duration of the leaves that are taken and whether employees need to pay overtime or hire replacement workers. Stakeholder reaction is expected to be very minimal to the changes to the code. We'd be pleased to address any questions that you have.
Okay. Mr. Connell and Mr. Dussault.
Thank you, Mr. Chair. Sorry, excuse me. I would just want to first ask the question in regards to the definition or term family member in regards to compassionate care benefits. How will that be determined? What is this defined as for family member in these changes?
Thank you for your question. So when we talk about family member in the EI Act, it's currently defined as the immediate family as well as extended family members. It is a long list, including grandparents, aunts, and uncles.
So it could it include niece, nephew, like if we're talking about, a younger person perhaps taking care of an elderly member of their family?
If the person is an EI eligible person and meets the definition, then yes, they could be taking care of an older family member.
How would somebody know, though? Would it be an application process to quantify whether or not they're eligible?
So in terms of EI eligibility, to qualify for all these special benefits, maternity, parental, compassionate care, sickness, you need to qualify with a minimum of 600 hours in the past year, or you could be a self-employed person who's voluntarily opted into the EI program. If you do not have them with minimum income, if you do not have these hours and you do apply, your claim would be rejected. If you have the hours, you apply for the particular benefit and meet other requirements, then yes, you would be eligible.
Okay. In regards or in relation to the maternity leave components, two issues have recently come up, at least in my riding, and I suspect I'm not alone, but the expansion or the changing through this legislation of allowing for up to 12 weeks for maternity leave prior to giving birth. However, some of the concerns that we hear about are around also the eligibility, and so I'm assuming that those other conditions have not changed or have not loosened. And I'll give my two specific examples. A resident who's pregnant goes on maternity leave. When she is set to return to work, she's laid off. But because she's been off on maternity leave, she hasn't had her, I think, 52 weeks prior to being laid off. Therefore, she's ineligible for EI. And yet her male colleagues who were also laid off would have been eligible. So in the other situation is a situation where a person was pregnant, took her maternity leave, returned to work, and quickly got pregnant again and was shy of a few hours of being able to qualify once again, could not have any accommodation made with her employer to make up those hours to be able to be eligible. Does anything in this act start to address these the flexibility issues around benefits when someone is either on or off maternity leave, and these types of situations need to kick in, for example, someone being laid off or needing to access maternity leave benefits once again?
Okay. So thanks for that question. And as you may know, the Employment Insurance Act is a very complex piece of legislation. Now, in terms of the changes that are being proposed in Budget 2017, there's specifically the new caregiving benefit as well as flexibility with respect to the maternity and parental benefit. There aren't changes which are specifically aimed at increasing eligibility for EI in these provisions, nor to address the situation that you've identified there of a person who's completed one EI claim and who subsequently there's another insurable event, whether it is job loss, whether it's maternity, whether it's a compassionate care situation, and being able to requalify. So if they're short hours, this doesn't do anything for them. Similarly, if it is a woman who's been off on maternity and parental, returns to work only to lose her job, this doesn't address that situation. There are some adaptations that we've made to the rules for the combining of EI benefits, which are to provide flexibility so that if somebody has just recently lost their job and then would still like to take maternity and parental, that they are able to access the longer duration option, but it is not increasing the total number of benefits that they would have access to.
Thank you. And knowing, Mr. Chair, that we are sticking to this bill, I do understand that there are another committee, I think HUMA, is looking at this kind of overall approach. So I would leave follow-up questions should that ever come forward. Thank you.
Thank you very much. Before we move to Mr. Dussault, technically our meeting was to adjourn at 5:30. I think we have general agreement that we will go until about 5 or 10 minutes before the bells. Approximately 6:15. Mr. Dussault.
Merci. Je pense qu'on a touché un bon point ici.
Thank you, and I think we touched on an important point here, which is the fact that at this time, out of 10 workers or 10 Canadian workers, there are 6 who are not eligible for EI. And I think that that's one of the fundamental problems with the current program. But here today, we're looking at the amendments to certain programs under EI and not looking at eligibility, as you mentioned earlier. But my question is more concerning parental leave and the changes to that. You've said that we now have the choice between 2 kinds of leave, either the normal or regular leave, as we've had already, or an extended leave. And I'd just like, for the benefit of Canadians who are watching us this evening, to know, when does the parent have to make a choice? But is that choice reversible? If a parent were to decide over the course of their leave, they decide that everything's going well and they want to go back to work earlier, is that possible, or is the decision irreversible once it's been taken? Well, thank you for your question. In terms of the choice of parental leave and benefits. That choice is made at the beginning when the type of benefit is decided. Parents will decide one or the other, and both parents need to choose the same option to have the right to the same number of weeks. The choice is irreversible as soon as the first dollar of parental benefits is paid out. But if the couple decides before the beginning, before they start to receive their benefits, they can call Service Canada to modify their choice. But as soon as $1 is paid out, they can't change their decision. They have to go to the end with their decision. Yes. And parents always have the right to go back to work earlier than the maximum number of weeks, but as soon as the choice of option is made, then that maximum number of weeks and that rate is set and cannot change, either 55 or 33%. So if a parent decides to go back to work earlier, they're going to have gotten 33% instead of 55%, so they would lose out in the end. Yes, having made that choice at the beginning of the benefits, yes. There are two things that have to be said about the return to work. Depending on the family circumstances, it's possible that the beneficiary might start again getting the benefits within the period. Also, when parents return to work, if they don't go back at full time, but rather, let's say, they go back for a temporary period, then they can work during the benefit period. And we have a pilot project. And I'll switch to English.
To retain some portion of their EI benefits while working, depending on how much they make in that period. And then if they do return they stop working, they may continue to receive their EI parental benefits.
Et si on envisageait dans ce comité de changer...
And if this committee wished to make amendments to the act that's before us to allow parents to change their decision, is that something that would be difficult for you to administer? Would that make it harder if parliamentarians were to make that amendment to allow parents to change their decision administratively? Would that be much more complex, or would it be relatively simple?
It would be complex. That would certainly be thinking about from perhaps a service delivery perspective, but I think there's another really important stakeholder here beyond the parents, and that's also the employers. And in terms of the consultations that were undertaken before moving forward with this, one of the things that we really heard from stakeholders was some concern. They were one particular group that had concern with a longer duration of parental leave and benefits, and but also particularly the importance for them of some degree of certainty in terms of when the employee would be returning back. So certainly if that employee is making changes to their period of leave, that could create difficulties for the employer in terms of being able to backfill or to staff positions behind that person on parental leave. So I think, given the sort of feedback we heard, that is not necessarily something that would be well received by some groups.
Merci pour la réponse.
Well, thank you for your answer. Otherwise, do you think that this is a major advance for parents in Canada to be able to, well, I see this as exchanging 25 cents for a quarter, because you have the choice of more weeks at 30% or the regular number at 55. So at the end, you receive the same amount, but just over a longer period of time. Do you see this really as a major advancement, or is it just a modest change, or really something that's 6 of one, half a dozen of the other?
That we have heard from parents who welcome the ability to take leave and benefits over a longer period of time, so that they might be able to reach a period of receiving affordable childcare or having access to affordable childcare. We have, if you think more broadly about stakeholder reaction to the budget announcement, they've been, I would say, very positive with respect to caregiving, and it's been more mixed with respect to the parental changes, in that some stakeholders have said that living on a 33% replacement rate is expected to be difficult, and they don't necessarily see that as a good choice for many families. I should add, though, that one element of the EI program, which is the EI Family Supplement, will continue to apply over that extended period of 18 months, so that in the case of a low-income family, they would receive a top-up not just over the 12 months, but over the full 18 months if they choose that option.
Merci. Ça fait le tour.
All right. I don't have any other questioners, so thank you very much. And we will move to Division 15, Minister of Transport. We have Marie-Hélène Levesque, who's the Executive Director of Cost Recovery, and Mary O'Connor, who's Legal Counsel. Turn it over to you for an opening statement.
All right, thank you, Mr. Chair.
Okay.
So concerning Division 15, this pertains to the amendments to 4 acts under the purview of the Minister of Transport: the Aeronautics Act, the Navigation Protection Act, the Railway Safety Act, and the Canada Shipping Act of 2001. Collectively, these amendments will allow the Minister of Transport to enter into service level agreements or contracts with industry organizations for activities in the aviation, navigation infrastructure, rail, and marine transportation sectors. The amendments proposed here do not create new fees. The amendments do not raise existing fees either. These amendments give the Minister of Transport the ability to sign contracts for services with organizations and users of TCs, of Transport Canada services. These amendments will also allow the Minister of Transport to spend the funds received from such an agreement in one fiscal year or in the next one. This is in recognition of the fact that service level agreements will be signed in respect of work that is likely complex and time consuming and done in the span of more than one fiscal year. With that, Mr. Chair, that concludes my opening remarks.
Okay, thank you. Does anybody have any questions for Part 4, Division 15 on agreements with the Minister of Transport? Hearing none, you're really going to get off easy, Ms. Levesque. Ms. O'Connell, it was a good job you waited for this moment. Thank you both. Turning to Division 16, Food and Drugs Act, with Health Canada. Okay, and back this way. Okay. All right. With from Health Canada, we have David Lee, Executive Advisor to the Assistant Deputy Minister, Assistant Deputy Minister's Office, Health Products and Food Branch. We have Ms. Minto Said, Director, Strategic Planning and Accountability Division, Resource Management and Operations, Health Products and Food Branch. Mr. Morgan, Director, General Policy Planning and International Affairs Directorate, Health Products and Food Branch. And Ms. Traherne, Mr. Traherne, Director, General Resource Management and Operations Director at Health Products and Food Branch. Welcome all. Part 4, Division 16 is yours to behold.
That's great. Thank you very much. We're very happy to be here today. Like our counterparts from Transport Canada, our proposal touches on user fees primarily and the Minister's authorities under which to set them. So as you know, Health Canada regulates the safety, efficacy and quality of drugs and medical devices in Canada in both a pre-market and post-market regulatory space, and has been doing so for quite a long time. Since about the mid-1990s, we've been charging user fees for those functions as well to subsidize the cost of the regulatory cost to taxpayers. So today our proposal essentially is requesting a revised authority for the Minister of Health to move the fees from under the FAA, where they refer to the Food and Drugs regulations, and move them directly under the Food and Drugs Act, and to modify certain parts of the Food and Drugs Act to make that a better instrument to do so. Essentially, this is not going to raise fees. It requires that we consult with all our stakeholders and continue to apply all the Statutory Instruments Act requirements as well. But it will set a comprehensive policy frame under the Food and Drugs Act under which we can charge user fees, and it will do it in a streamlined fashion. Currently, under the GIC full regulatory process, it can take anywhere from 2 to 4 years to update a fee. So we're envisioning a more agile and kind of globally comparable user fee regime where we can do those fee updates probably within 12 to 15 months. So that's Part 4 of the Division 16 of the Budget Implementation Act. It also allows for an exemption to the current, the renamed User Fees Act, which is the Service Fees Act, which our colleagues from Treasury Board Secretariat are going to speak to, and which we support wholeheartedly. Essentially, under the proposed framework, the Minister of Health will keep, as I said, all the accountability and transparency principles, including the requirement to consult stakeholders, performance penalties, small and medium enterprise mitigation, and we believe there is no impact on the provinces and territories or on Canadians directly because the fees apply largely to industry and the pass-through is very minimal to non-existent. So I think I'll just stop right there and take your questions.
Okay, starting with Mr. Leipert.
Very briefly, if I heard you correctly, there's no change to fees in any of this?
What it allows us to do is when we go to reset the fees, pursuant to consultation and everything else, we'll do it under the Food and Drugs Act.
Yeah, but I guess my question is, why is it in this budget bill if there's no?
It's to modify the Food and Drugs Act itself. It's the instrument under which we are doing the changes.
Well, wouldn't you do that? Wouldn't you modify the legislation that you're modifying without bringing it here? I'm just having trouble understanding why it's part of a budget bill.
Well, essentially the Food and Drugs Act has elements in it which allow you to charge fees, but it's not a comprehensive instrument to do that. So what we're doing is modifying it slightly to allow us to have a more, robust fee-setting instrument to then go and charge fees.
Right, that's all I had.
Mr. Dussault.
Merci. Juste que c'est de confirmer, selon ma compréhension.
Thank you. I just want to confirm, according to my understanding, the minister can change or adjust the fees without consulting industry. Is that correct? According to the amendments that are proposed, the minister could make changes to fees without consulting anyone. Well, if I understand correctly, as I've already said, we are adjusting the instrument, quite simply, but before changing any fee line,
there's a requirement to do that, and that's in the legislation. So the FDA says thou shalt consult your stakeholders on this before updating any fee. So we currently have fees, as you know, and we've had them for about 22 years. They've only been updated once in those 22 years. And essentially, all those consultations, the last one was 2011, and that's pursuant to a full consultation, and it was also presented here as well.
Okay. Donc, il y a une obligation de consulter dans la loi déjà.
There is an obligation to consult under the law already. Absolutely, yes. And under the new Service Fees Act, the new law, it's in the bill. Well, why are these fees from the Health Act, why would they not fall under the Service Fees Act? Is essentially what we're proposing. We're asking for an exemption.
Actually meet all the requirements and the criteria that are in it. In addition, we are in the world of, pursuant to Budget 2017 and some of the transformations that are going on there in the pharmaceutical, medical access and affordability world, we are already building new regulatory processes under which to transform how we do our work. So it is a 15-month process minimum, probably more like 18, to lift and shift our current set of fees under the Food and Drugs Act. So we thought that given the ambiguity about the timing of the implementation of the TBS changes and the coming into force therein, we thought it would be better to get out ahead of that. In addition, we're talking about a comprehensive approach under the Food and Drug Act, which aligns to the policy, to the instrument the minister has, and the minister will set fees through ministerial order. But ministerial order is not, it is not, a blank check. It is essentially a regulatory process light and has all the elements of the regulatory process. It just basically minimizes a few of them so that we can be able to do this, more than once every 22 years.
If
I understood correctly, you'll continue to have an exemption under the Service Fees Act, and you'll be exempt from that law, but you have the same standards. Absolutely, yes. Health Canada.
A globally competitive regulator. Our performance is comparable to any of the major regulators in the world, the FDA, the EMA, the Australians and the New Zealanders as well. We charge a fraction of the cost, of the regulatory cost to industry to do those same reviews at a competitive pace while protecting the safety and efficacy of the drugs. So we feel that this is a very comprehensive, it's robust. We have a long experience here. We're a long way from the implementation of the User Fees Act in 2002 or 3, and we think we're in a different situation now.
Merci.
Thank you, Mr. Dussault. Before I go to Mr. Diddletel, these user fees, there's other agencies beyond Food and Drug, like there's the under Health Canada, there's the Canadian Food Inspection Agency, part of that now. There's, I believe, Pest Management Review Agency. No, that's not under you guys. Does this relate to any of those fees?
It does not, actually. Those are other organizations within the health portfolio that have either, in the case of the CFIA, already has this exemption. So what Health Canada is asking for here is not unusual. There are several examples in the BIA as well. And there are other departments that currently have these authorities and these exemptions.
So, and this is not in any way tying fees to the consumer price index like we're seeing in some other areas?
The fees currently have an index factor, an inflationary factor in them. In fact, under the new Service Fees Act, that will be a mandatory requirement for all departments, that is one of the few positive aspects of the user fee regime that we have, given that it is now 6-7 years out of date. The escalator has prevented the attrition of resources, which would impact on the safety and the performance of the regulator. So, but we're in a world now where it's been 6 or 7 years, and we need to get out of the gate, refresh those fees, and ensure that industry pays its fair share and taxpayers are also paying their fair share. And that's why we'd like to move along on this.
So when you do increase these fees in your consultation with industry, is there, I guess my view is Ottawa often works in silos. And is there any consideration given to the impact these fees can have on the economic viability of those areas that these fees apply to in terms of their business and commercial operations?
Absolutely, that's a requirement of our approach, and it's a requirement of the Statutory Instruments Act as well as the Cabinet Directive on Setting of Regulations, is that the regulatory impact analysis studies are a mandatory piece of this, and that will continue. As I said, we have a list of about 12 things that our current regime has under the FAA, and all 12 of those things will basically exist under the FDA as well. And so the requirements to study the impact on industry is a mandatory requirement, and we will continue to do that. The pharmaceutical industry in Canada is actually quite robust, and I think Industry Canada or I said could comment further on that kind of stuff if you had questions about that. It's not our expertise to be, to understand the market as a whole and all its dynamics, but we do assess the impact. As I said, also the fees globally, what we're talking about here is that all the major regulators in the world charge somewhere between 80 to 100% of the cost to the industry to regulate those products. Health Canada is in a world right now where we're regulating we're subsidizing the cost, and fees amount to about 40 to 45% of our cost. So we are much lower than the global reality, and the fees are a fraction of what, for instance, the FDA in the United States would charge $2 million, for a major new active substance drug review, whereas we're charging about $250,000, $300,000. So.
Last question I have, is there any kind of a appeal process set up that those that, when the fees are announced, can make their point?
Absolutely right. I mean, first of all, they're subject to consultation and negotiation and an understanding of the sectors of the industry. And second of all, there is a dispute resolution framework that we'll put in place as part of this. That's never been a major issue with this industry that we face. It's usually subject to the consultation piece.
Sorry, Mr. Deltel, the floor is yours.
Thank you, Chair. Messieurs, Madame, soyez le bienvenu à votre chambre.
Welcome to your House of Commons.
Simple example that you have a problem today in your department that will be fixed with this bill.
Absolutely right. I can give you several. As I said, the fees have not been updated in 6 or 7 years. Those fees were based on costing from 2008. So what we're talking about is moving resources from other parts of our branch, for instance, in Health Canada, to subsidize the cost of doing these regulatory reviews. So that, you can only sort of rob Peter to pay Paul for so long, and that's kind of the state we're in. We continue to meet our performance standards, but every year there is a situation where we will have challenges with that, and we have to reallocate resources to do that. And we report publicly on this data every year as well. Do you have another example you want to talk about?
Certainly. In the past, we have had incidents where when we're changing our regulations, for example, a few years ago, we put in new regulations to govern active pharmaceutical ingredients. This is how you make them to make sure that they're safe. And under the current regulations, to change and introduce new fees, in our experience, took 2 to 3 years. And it wasn't rapid enough to bring in new costing for that framework. So you had inspectors going out, you had resources deployed from the department, and yet we couldn't catch up with the regime. This new mechanism will allow us by ministerial order, with consultation with all of the resolution mechanisms, to move a lot quicker and harmonize new regulations coming in, of which we're looking at many departmentally.
What kind of fees need to be fixed under the Aeronautic Act, navigation, railway safety, and Canada shipping? Because you talk about medication. Okay, what is the link with transport?
So there's not a link here with transport. Transport needs its own regime under its own instruments. Here, under the Food and Drugs Act, we have tailored the mechanisms to really serve our regulatory environment, which is very complex. If you look at the Food and Drugs Act, there's a lot of regulations and a lot of oversight that we give for medical devices, for drugs. And so we've written a set of rules that will apply specially for this environment.
Elaborate. Basically, all the departments that charge user fees do it individually under their regulations generally, okay? And with the Transport Canada folks that we're just presenting, we're talking about was non-regulatory areas where the minister would enter into an agreement to charge fees on a voluntary basis, right? So they're quite complex and they're subject to each department's stakeholders and industries and consultations. But all that is sort of governed by the principles of the Service Fees Act that Treasury Board is bringing forward. But some departments have been in this business quite a long time and have very robust frameworks already, right?
Mr. Dussel?
Rapidement, parce qu'on parle des compagnies pharmaceutiques.
Very quickly, Bruce, we're talking about pharmaceutical companies, and let's say they're not the companies that have the most to complain about in our society, and we're talking about them paying their fair share when it comes to the review of their products by Health Canada. What would happen in a hypothetical situation where we would ask them to pay a lot more than the fees that are associated with the approval of their medication? So if it costs taxpayers millions of dollars to accept and approve, if the process costs the public purse millions of dollars, what would happen if we asked the pharmaceutical companies to pay the full price of that? What would that do? Well,
if you say a health product costs $10, the fee to the industry represents 1 cent of that $10 currently. So it's what would happen. I mean, as I said, globally we know that others are charging 100% cost recovery and much larger fees, and there has been no negative impact on industry that we know externally. And in fact, the fees were set quite low in Canada in the 1990s to be sympathetic to the challenges of the industry and to make sure that these didn't cause deleterious economic impacts. So, in terms of raising the fees substantially, we don't know what the impact would be, but that would be subject to analysis and discussion with the stakeholders to talk about what the regulatory impact analysis would show.
Mais ça se fait ailleurs, donc c'est possible.
This is done elsewhere, so it would be possible.
We do, I think we're in agreement with staying until 6:15. The vote will be in a little over 22 minutes, so we're okay. We're only up the hall. Mr. Fergus.
Just to follow up to Mr. Dussault's question, maybe a couple of questions for you, Mr. Traherne. In regard to the U.S. case where the drug companies would pay a full fee or a greater percentage of the costs which are incurred by the FDA, that would be accurate, I'm assuming.
You're absolutely right.
Is it full cost recovery in the United States?
It's above cost, actually, in some cases, but it is 80 to 100%.
Okay.
Yep.
Amongst the OECD countries, I imagine that the price for research-based or original drugs, brand name drugs, it's the highest in the United States, is it not?
It is one of the countries, for brand name, yes, but for generics, no.
Right.
And
Canada has the highest in generics, and the
Yes,
U.S. has
exactly.
the highest for brand name. I'm talking about brand name. Which OECD or G7 country has the lowest brand name drug prices?
Well, I mean, it's not really my field of expertise in terms of the pricing model. I mean, there certainly if you look at the comparators that Health Canada looks at, a lot of the Scandinavian
Let's say
countries,
the basket of countries that we.
Yeah, many of the European countries pay far less. Australia, I do know a little about, for instance, but you're talking about there's one door into that country. It is the front-end regulator, and they set fees based on negotiations to access the market in Australia as a whole. Whereas here in Canada, we regulate the health and safety of a drug, but there are multiple buyers, as you know. Mm-hmm. And there is but
let's assume like the Scandinavian countries or the UK would have lower brand name drug prices.
Right. Yeah.
What do their equivalents of the FDA or Health Canada what are their charges to the industry?
Yeah, the EMA charges, I believe, is at 100%. And I couldn't quote you their absolute cost for, say, a new active substance review, but we could get that information for you if you'd like.
So there's no correlation between the fees that are charged by the health authority and the brand name.
In fact, your point is well taken, sir. Is essentially they're charging more for the cost recovery of the fee review of the drug review, but the cost of drugs in the country are lower generally.
Okay, so you wouldn't accept any argument by the brand name drug companies that this would just increase the cost to the consumer, to the client?
Obviously, in a consultation, I would have to listen to those arguments for sure, but as to their merit and the evidence base around them, I would have to look at the evidence there. It's hard for me to say.
Hard for you to say, or would it be, there just doesn't seem to be a correlation?
Certainly, well, I've never done a comprehensive study, but globally it does not seem to be correlated.
Thank you.
Yeah.
Okay, and I have one further question as well. Could you just I asked a couple of questions earlier. Could you tell me the process that what process would a stakeholder have to challenge these user fees under these proposed amendments? What's the process? I mean, I pay user fees in my other life. And we're never happy in the farming sector about user fees, I can tell you. So what processor would there be for a stakeholder to challenge these fees under this proposed amendments?
We have several. I mean, one, as I said, is the consultation proper and the discussion there and the negotiation on what the fee should be, looking at the impact on those sectors. And as I said, I'm very glad that I'm not in the farming sector when I'm trying to set fees. Secondly, we have a small and medium enterprise fee mitigation policy, so that any small and medium enterprise can benefit from a reduction in fee, and we have excellent take-up on that process. And we've done audits of it, and it's in very good shape. So the people taking up those, the reductions in fees have a right to that, and there's good evidence to suggest they're the right people getting it. So we've done audits in that. And then thirdly, as I said, we're going to create a dispute resolution system around this, where the stakeholders can come and discuss with Health Canada. And this will be, of course, something we have to work on over the coming months as we develop this new regime with our stakeholders to kind of look at where and how that's going to work. But dispute resolution is something that we're planning on doing. And as I said, fourthly, we rarely have that kind of impact when we're talking about the stakeholders in particular that we have in Health Canada.
Okay, Mr. Dussault, last question with this group.
Non, juste pour savoir en termes de chiffres combien ça.
Well, just in terms of numbers, user fees at Health Canada for the approval process, what does that represent to you? For example, a pharmaceutical company that wants to come forward with a new drug, how many dollars does that represent on average, this approval process? In terms of total revenue for our department, with the total cost of a drug?
We currently are charging about 40% of the total cost for a drug review, and that's based on 100% time tracking. So we know the costs are quite activity-based, they're not just a guess. So we charge about 40% of the true cost of a drug review right now. In terms of revenues, total revenues for the department, I believe ourselves and then one of our counterparts that does the compliance and enforcement, the post-market compliance and enforcement, together we raise about, is it $90 million? $97 million a year, which represents about 50% of the budget, or just under 50% of the budget, as I said, of our entire branch.
Merci.
Mr. Fergus, last question.
Just one last question, to follow up to the chair's question, really. I'm trying to understand, so as we now authorize effectively Health Canada to be able to administratively determine what the user fees should be, and that would be reflected on the full cost of the services which are provided. If a pharmaceutical manufacturer contests the fees that are being charged, they might consider it out of line, out of whack, or not reflective, the recourse of that company would not be to the minister, I take it. Or would the minister have the ability to overrule the department?
Well, the minister would receive a proposal from us on the proposed fees to be changed. So the minister would have the final authority here in that sense, in setting them through a ministerial mandate. Also,
every time the fee changes, the minister would have to give her or his approval?
Correct. That's the proposal. Sorry, David.
It may be important to note, when we establish fees now, it's under the Financial Administration Act, so it's a regulation-making process.
Right.
This will be the same. It's just a different form of regulation. So we're going from the Financial Administration Act over to the Food and Drugs Act, and you do it by order, which is still a form of regulation. So it would enjoy gazetting the same process in terms of guaranteeing representations as the normal regulation making.
So I'm just trying to think back to the FAA in the sense when decisions are made, usually ministers would say, "Thank you very much. That decision's been made by the FAA. It's been handled. It's no longer. There's no more appeal to me." That's what usually happens. You're saying that would continue to happen.
It would continue to happen, but it shifts from the FAA into the purview of Minister of Health, but it has the rigor of the Statutory Instruments Act, so it behaves like a normal regulation-making process in that sense.
In a sense, it's out of
but it doesn't go to cabinet, it stays with
it's out of the minister's hands.
Correct.
It doesn't go out, okay.
Correct.
So there is no political recourse then for...
It's the same recourse with any regulation-making that they would have.
Thank you. I just want to make that clear.
It doesn't go to one of the advantages with it going to cabinet, and I know you're saying it's not, and I understand that. One of the advantages is that other ministers can argue the point based on a memorandum to cabinet that this is going to affect their industry. You know, how often when things are gazetted and it's increasing costs to industries is it ever rolled back? I don't know of ever. So I think you're hearing from members there's a little bit of concern on user fees and whether or not the efficiencies are there in the departments and on the government side to make savings in other areas rather than just imposing additional fees. I think so. What you're hearing is some concerns. In any event, I think that's it for questions. We appreciate your fairly direct responses to those questions. And we will adjourn, but for those that are, I apologize to those that came for Division 17, 20, and 21. We won't be able to get to them. We'll have to schedule you in at another time. And we have divisions that have been firmed out as well. So in any event, the clerk will be back to those groups that didn't get on. I appreciate you having sat through the hearings to be available. Meeting adjourned.